ready.
Hi, this is Ed Sullivan and Marco Berti. Mark's a board-certified labor and employment lawyer who has a lot of cases under SOX Retaliation. Mark, why don't you talk about the latest developments in this extremely hot area of employment law?
Yeah, they've been remarkable. It's been a reversal of fortune. As you might know, SOX was passed in the wake of the Enron collapse and debacle. And there's a whistleblower provision. But unfortunately, or fortunately, depending on your point of view, for about the first 8 years after that law was passed, there was 1,273 SOX claims brought for retaliation. Only 17 of those claimants prevailed.
Wow.
So it was a massive, basically, waste of time for people trying to get any sort of relief as a SOX whistleblower. But all that changed in May 2011 when something called the Administrative Review Board, which is a 3-member panel, 2 of them are appointed by the president, so you had 2 Democrats by this point in time, decided a case called Parexel. And what they did is they dramatically broadened what the test is for engaging in protected activity under SOX from what it had been before. And so now most of the people who have some complaint, somehow even tangentially related to securities fraud, are going to be considered to have engaged in protected activity under SOX. And since Parexel has been decided, there's been a series of favorable decisions from the Administrative Review Board and administrative law judges in favor of SOX plaintiffs. And even more recently, the Administrative Review Board decided that SOX applies to the contractors of private companies, which contrasts with the First Circuit Court of Appeals decision. And so there's a real momentum, and who knows how the election's going to turn out, and that'll have a big effect on whether that momentum continues or not. But the bottom line is, if you're an employer, you really need to be on top of things when it comes to SOX whistleblowing, because it's a viable option now. The tiger is no longer toothless. Thank you.